Hello and welcome, I'm John Peters, Commercial Director for Hooper Enterprise Associates Limited, or Hill Planning as we're better known. This video is a case study detailing a recent enforcement planning appeal in the Cornwall Council area, where the council had served an enforcement notice on our client to cease using the building as a residential dwelling, remove UPVC windows and reinstate timber ones as original, or block up the openings, remove the plastic cladding from the building and reinstate timber materials as original. Before I start, I'd like to clarify that the client has given us full authority to use this information in this video. This case started for us when we were contacted by our client after their recent retrospective application had been refused by Cornwall Council and a decision notice had been issued to our client refusing the application. The client felt the decision was unjustified and that many parts of the enforcement notice were false, with incorrect information being stated by Cornwall Council. The client stated that should they lose the appeal, then they would lose their home. The building was already in place and used previously as a storage shed and had been in need of repair and renovation, which the client had completed. Our client was not prepared to simply give up to the enforcement notice, especially as they felt that it was incorrect in many parts and wanted the merits of this case taken to the Planning Inspectorate. The enforcement notice was served on the 19th of July 21 and our client had until August the 23rd to appeal, which was 28 days. The vast majority of enforcement cases have only 28 days to appeal. Some enforcement cases have a slightly extended timescale, especially during the pandemic, where an extra 7 to 10 days were added by some local authorities. The client instructed us to proceed immediately with the planning enforcement appeal due to the dramatically reduced appeal timescale. It is vitally important that we start the appeal documentation as quickly as possible. The enforcement notice reasons were stated that it had appeared to Cornwall Council that a breach in planning control had occurred within the last 4 years. The material change of use and operational development in question was undertaken less than 4 years ago. The development results in a material impact on the amenities of the neighbouring property due to the overlooking of the private rear amenity space of a neighbouring property, caused by the close position of the development, and therefore is contrary to Policy 12 of the Cornwall Local Planning Statutory Policies 2010 to 2013 and paragraph 127 of the National Planning Policy Framework. Additionally, the development, by reason of its design and appearance, use of colour, cladding and UPVC fenestration does not conserve or enhance the conservation area. Consequently, the development fails to accord with policies 2, 12 and 24 of the Cornwall Local Plan Strategic Policies 2010 to 2030 and paragraphs 124, 127, 185, 186, 192, 193, 196 and 200 of the National Planning Policy Framework. The Council do not consider that the planning permission should be given because planning conditions could not overcome these objections to the development. The Council required, as part of the enforcement notice, that the client 1. Cease the use of the building for residential purposes, 2. Remove all the UPVC windows from the building and reinstate timber ones, 3. Remove the plastic cladding from the building and reinstate timber materials as original. The Council gave our client 12 months from compliance after the notice took effect on the 23rd of August. This enforcement notice was very comprehensive and clear what the Council's wishes were and when they wanted them complied with. We at Hill Planning have a lot of experience detailing with enforcement notices in Cornwall and across England as a whole, with both in-house legal and planning teams who both work on these cases, providing our clients with their best chance of success. For this appeal, we produced a very detailed enforcement appeal statement that was 49 pages deep, building a case that detailed each part of the Council's reasons to be wrong and why Cornwall Councils were wrong to issue this enforcement notice. We also were able to prove that some of the work listed in the enforcement notice was in fact completed over 4 years prior to the enforcement notice being issued and was in fact immune to enforcement action altogether. Providing a comprehensive and robust argument, bringing national and local policies into play and detailing reasons as to why the findings were wrong and in fact the development was perfectly acceptable. Additionally, our client provided a complete detailed list of other properties in the area that were similar, and we completed a further amount of research to find very similar cases that the planning inspectorate had previously granted, and we looked to use these cases to support our argument as best possible. The appeal was made under grounds A, C, D, E and F. As this appeal was an enforcement appeal, the local authority in which this case was Cornwall Council have the right to respond to our appeal statement. Cornwall exercised their right to respond with a detailed 36-page document to respond to our appeal statement in an attempt to strengthen their argument and overcome the details and facts we had put forward. We produced a rebuttal document to counter Cornwall Council's response to our appeal statement, and our client also produced a 5-page personal statement that related to other local non-planning matters. This case, like the vast majority of similar cases, was dealt with by way of written representation. The inspector visited the appeal site on the 31st of January 2022 and issued the appeal decision on the 14th of February 2022 in a 7-page, very detailed report. The good news was that the appeal was upheld and the permission was granted with previously agreed conditions. Our approach for producing appeal documents that go into great detail to work through the refusal reasons, officers' report policies in detail, and to supply supporting cases where the inspector had granted similar appeals is invaluable. This gives the client their best chance of success. Admittedly, it does take longer to produce and increases the cost slightly by going into that level of detail, but it is that attention to detail that is absolutely paramount. As an organisation, Hill Planning is one of the leading appeals specialists with both dedicated in-house planning and legal teams, whose job it is to win your case. Both these skill sets are invaluable to produce a robust and comprehensive case to gain a win. You won't find many organisations in our industry that have both of these skill sets, a planning and a legal team, and it is most definitely a major reason why we have the success rate we do. Without appealing your enforcement notice, you cannot gain the permission you would like. Your enforcement appeal will go to the planning inspectorate. They're a government-based organisation that is appointed by the Secretary of State to handle all types of planning appeals. Based out of Bristol and covering England and Wales, the Planning Inspectorate gives you a chance of success to gain that permission you are seeking and taking the decision process away from your local authority's planning officer. You'll find a host of videos about various types of planning appeals and the services we offer on our website. If you'd like a free no obligation consultation with myself or a member of our team, please call us on 01743 369 911 or email appeals@planningappealsuk.com and give your appeal its best chance of success. Thank you for watching and we look forward to speaking with you soon.